Oh, ever so much to get to in the back and forth of litigation against Illinois' gun ban, as somebody posts on YouTube. It is now 72 days of Illinois' gun and magazine ban being in place. And we've been basically every day getting updates from various angles, be it the federal cases or the state cases against Illinois' gun ban. This is just one particular law in the state of Illinois we've been focused on in the litigation because it is so broad. Now, there's so many other cases, not just in Illinois, especially about the FOID card, for instance, which we'll definitely be looking for updates on that sometime soon. Challenges against the firearm owner identification card being unconstitutional. And you've got other cases across the country as well that very much deal with Second Amendment issues, everything from, certain types of parts to, different types of lists of what is or is not a legal gun to be allowed. These are, of course, all things that very much need focus, but we've been focusing almost exclusively on Illinois' Protect Illinois Communities Act, which was signed January 10th. And again, somebody noting now 72 days in of that bill being enacted into law, a ban on more than 170 different firearms, semi-automatic shotguns, rifles, handguns, and a ban on magazines of more than 15 rounds for handguns and more than 10 rounds for rifles. All of those have not been able to be sold to you, the individual, here in the state of Illinois, unless you are a police officer, retired police officer, jailer, warden in the security space. So you've had all these lawsuits filed. We've got some updates on various cases, and we'll start with the case that attorney Thomas DeVore brought, Accuracy Firearms, which is actually the first case that actually had some movement in state court. And if you recall, he got a temporary restraining order in place based off of the issue of equal protection, saying that essentially the equal protection element of your rights was violated whenever the state decided to carve out police, allowing them to have access to these firearms, while the regular citizen, who also has a Second Amendment right, does not have that same access. So most recently, yesterday, you had on the docket for Accuracy Firearms, and again, this is the case that got that first temporary restraining order in state-level court out of Effingham County that the state appealed to the appellate court, and the appellate court upheld the temporary restraining order on the grounds of equal protections. That led to a domino effect of similar cases having temporary restraining orders, two now in Effingham County, thousands of people, one in White County, again, a DeVore case, and then the fourth case is the Macon County case. That case, separate, is now up in front of the Illinois Supreme Court on appeal. So those are the state-level cases, but when it comes to the Accuracy Firearms case, there is an update, kind of a mixed day of sorts yesterday. So let's go ahead and check this out from the docket, and we'll read this from the docket item here. Plaintiffs by attorney DeVore and Drew, defendants by Vaught, Kincaid, Cunningham, Casper, Bruce, and Casson for Illinois Sheriffs and Chiefs of Police. You've got the Illinois Sheriffs Association there and the Chiefs of Police there to essentially motion to quash a subpoena that DeVore had filed to get information from the Chiefs of Police and the Sheriffs Association on what kind of negotiations there may have been on crafting and ultimately getting this law approved. Now, we know that the Sheriff's Association has filed in federal court to oppose the state's gun ban, but they told us that they don't see it necessary to give over information in the state-level case as DeVore is asking for it. But DeVore, he's subpoenaed a substantial amount of information on not just from the sheriffs and from the chiefs of police, but also from the various legislative leaders and even the governor. But here we are with the motion to quash was granted, and that was done on procedural grounds according to this docket order. Now, DeVore, he could file amended subpoenas for the Illinois Sheriffs and the Chiefs of Police Association, two separate associations who got that motion to quash granted, so they don't have to reply to the subpoenas. However, DeVore could file for an another subpoena. So that's one thing. DeVore is going to have to do a little bit more work on that. But when it comes to a different argument that the state had brought, the state apparently defendants, they had a motion to stay pending any outcome from the Illinois Supreme Court. And the docket order here, it says, for the reasons stated on the record, and this was done remotely, the motion to stay is denied. So this case, Accuracy Firearms, is going to be moving forward in Effingham County. So the state tried to stay it, to not let it go forward, to hold it in place, frozen, while the Illinois Supreme Court deals with what they've got to deal with the Macon County case, and they won't hear that until mid-May. But the Effingham County Accuracy Firearms case, where 3 of DeVore's cases have been combined, that's going to move forward. But DeVore's going to have to take a look at the subpoenas that he issued to the Illinois Sheriff's Association and the Illinois Chiefs of Police Association. All right, let's go and take a look at the federal court, where you've got the 4 consolidated cases in the Southern District, and those cases, of course, have had pleadings back and forth. We've seen the states issue thousands of pages of various evidence, dozens of pages answering, various allegations that the law violates the Second Amendment and so on. But what about the McHenry County case, where the state's attorney there, Patrick Keneally, filed a lawsuit against the bill in McHenry County? Well, if you recall, that case at state level court was actually transferred to federal courts, and the federal court docket last week was actually pretty busy, and I wasn't keeping an eye on this, but if you check this out, you can actually read here that apparently there was a motion from the state to essentially have a final judgment on the ruling, on the pleadings that have been filed. So the state motioned to move this out of state court to federal court, and then in federal court, they're saying, all right, you should just judge this based off the pleadings that have been made thus far. All right, and this is in the Northern District. Well, the judge filing back, and this is on the docket, you can read, the defendants removed this case, then moved for judgment on the pleadings based on the lack of standing. They have now filed a notice of withdrawal of their motion for judgment of the pleadings based on their conclusion that federal courts lack jurisdiction over this case, the case they removed to federal court. So what is it? Do the defendants believe this court has jurisdiction, which is the only basis to remove it here, or do the defendants believe this court lacks jurisdiction because the plaintiffs lack standing? Pick one and prepare to tell the court why. And if the answer is the court lacks jurisdiction, be prepared to tell the court why the case is removed to this court. Please keep Federal Rule of Civil Procedure 11 in mind during this process. Perhaps the judicial recourse is already expanded, could have been avoided had the defendants complied with the court's standing order to remove cases, specifically the unheeded requirements that any action removed to this court within 7 business days. Defense counsel must also file a certification that they have read this standing order. The parties are directed to review the standing order if they have not already done so, including the warnings about summary remands, awards of courts, and sanctions for unnecessary use of the court's time to be paid personally by counsel. That is rather fascinating. So several times in that, the judge has essentially said, the states, you could have saved some time and money having not done these pleadings back and forth, asking for removal, and then now asking for it to be withdrawn, and direct pleadings to be final judgments and so on. But then saying that the costs incurred by the courts could have to come personally out of the pockets of counsel. That's pretty incredible. So a couple of different updates there, right? All last week you had different filings in the McHenry County case that's now in Northern District of federal courts, but also with the Accuracy Firearms case in state court that is proceeding forward despite the state trying to say that they don't have, they want to see this thing put on hold while the Illinois Supreme Court deals with their case. Really incredible stuff. That's why we take every day to look at the different movements of these various cases, because there are a lot of moving pieces. It is Springfield's Morning News, and something we're going to be covering absolutely whenever it's in town, and that is iGold. That's coming up March 29th in Springfield, and you can expect it's going to be a pretty big deal. And I imagine that with the law that's in place and all of the litigation that there is, you're probably going to see a fair amount of people. So iGold, again, March 29th, downtown Springfield. Illinois State Rifle Association's got more information about that and all of the different types of details you need to know. 10:30 is when it starts at the Bank of Springfield Center. That's when the doors open, and then there's typically, traditionally, a march that takes place down the street of Springfield to the Capitol building. So we'll watch how that plays out.